Joe Biden came into office with high expectations to tackle the major challenges at the White House and DHS. DHS introduced new regulations to lessen burdens and bottlenecks in the immigration system in 2021 to reverse certain restrictive immigration policies from the previous administration, and in 2022 took few initiatives to reduce backlogs. In this video, we try to provide you more insights the U.S. Immigration Reform Plans 2022 and beyond.
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
Number 1. U.S. Department of State backlog should slow but won't disappear. In the last 2 years, the backlog at USCIS has skyrocketed, accumulating to almost 8 million open cases. Due to the closure of U.S. embassies and consulates around the world as a result of the COVID-19 pandemic's outbreak in March 2020, the U.S. Department of State will have an enormous backlog of green card applications by the end of the fiscal year 2022. There were more than 9 million green card applications who were still awaiting approval at the end of the fiscal year 2022. There are reportedly 1.6 million job-based applicants and roughly 8 million family members waiting for green cards. Some specialists, in particular U.S., believe that the backlogs to be a resource concern that would necessitate Congress to provide more financial support, given that U.S. is largely funded by application fees. By recycling biometrics for some applicants, the administration has reduced bottlenecks and delays. Restoring a Trump administration policy that permits U.S. to rely on prior decisions on requests for renewal and status extensions, adding manpower and overtime, and upgrading its lockbox facilities, will take effect in March 2020. Additionally, the State Department boosted manpower and training throughout the summer of 2022, which ought to enable these and other advancements that decrease processing times and increase flexibility to continue. Even with more people, it will take a lot of resources to finish the 8 million cases at U.S. and the 9 million at DOTS. It appears plausible to anticipate that tendency to continue into 2022 given the yearly growth in the number of applications submitted by the agencies. U.S. and DOS may be able to make a dent in the millions of open applications, though. In 2022, these backlogs won't be cleared. Number 2. Immigration reform through legislation could happen piecemeal. In December 2021, the Senate parliamentarian ruled that the Build Back Better Act, which Democrats are attempting to pass through the budget reconciliation process, cannot include provisions for work authorization for undocumented individuals who have been continuously present in the U.S. since 2021 and Plan C parole in place. The lawmaker has not yet been given the other immigration measures included in the House bill, such as a clause allowing for the recapture of green cards or allowing applicants to pay an additional fee to speed up their application. Therefore, it's conceivable that those ideas will stick. Immigration supporters and several Democratic politicians have demanded that the parliamentarian be disregarded or removed, but other senators have said they are opposed to this idea. A Plan D has not been disclosed by lawmakers. Therefore, the Build Back Better Act, which would alter immigration policy, is currently stuck in the Senate and may never pass. Nevertheless, some supporters continue to hold that, even though comprehensive immigration reform may not be feasible, there are specific policies that are popular with the public and could be implemented separately. For example, legislation to protect dreamers, essential workers, and individuals with temporary protected status is all very popular, and congressional Democrats will face pressure from their supporters to fulfill immigration pledges made on the campaign trail. Number 3. Improvements to the H-1B and work permit. The H-1B visa program, which allows U.S. employers to hire highly skilled foreign workers for positions that are difficult to fill, has been hinted at as a future improvement by the Biden administration. The program leans heavily towards STEM occupations, with software developers making up the largest portion of the pie. Given the labor shortage, particularly the persistent need for more workers in the STEM fields, the H-1B program has come under fire from both pro- and anti-immigration advocates. The Biden administration is working to restructure the program to address these various issues. Some claim it artificially drives down wages for U.S. workers. Others claim it can lead to foreign workers being exploited by unscrupulous employees. provide flexibility for new businesses, alter the definition of the employer-employee relationship, increase the pay for H-1B employees, and establish guidelines for employer site visits are some of the modifications that have been proposed for this year. Number 4. Executive action on immigration will be required if Congress does nothing. Given the extreme partisanship in Congress, it's unlikely that any significant immigration legislation will be passed in 2022, which means the executive branch's involvement in the matter may increase. As the previous administration did with the 2019 Public Charge Rule and the 2020 FEET Rule, for instance, last year we saw the American Dream and Promise Act and the Farm Workforce Modernization Act, both of which passed in the House before failing in the Senate. This could also take the form of presidential proclamations and executive orders or increased use of the agency rulemaking process. The Build Back Better Act was just passed by the House as well, but it has been held up in the Senate due to budget reconciliation rules and horse dealing over climate change and the child tax credit. Despite 72% of Americans supporting a path to citizenship for Dreamers, the Dream and Promise Act is essentially dead in the Senate. In response to this stalemate and the ruling of a federal judge in Texas, the Department of Homeland Security, DHS, issued a proposed rule to codify the DACA program after public notice and comment. The rule will be finalized and become part of the Code of Federal Regulations, which governs immigration law along with the Immigration and Nationality Act. With obstructionism reaching staggering new heights in the Senate, we should expect to see a greater use of executive power from the President himself as well as through his cabinet agencies in their rulemaking. Number 5. Immigration fee hike. The State Department has proposed significantly increasing fees for most non-immigrant visas in 2022 visitor visas B1/B2 and student visas. FMJ will likely increase by more than 50% from $160 to $245. Employment visas will see an even greater jump from $190 to $310, a 63% increase. The new fees will go into effect before September 2022. Number 6. Litigation will continue as the Biden administration struggles to undo Trump ERA policies. The last 5 years were marked by extensive and ongoing litigation, and 2022 shows little sign of departing from that trend. At the close of 2021, there were active lawsuits over the migrant protection protocols remain in Mexico. President Biden's ICE enforcement priorities: work permit processing delays, asylum restrictions, public health orders at the southern border, and whether the federal courts have the authority to review DHS's decisions on whether a non-citizen can be protected from deportation. These cases will continue in 2022, likely with more to join them over the past 10 years. We have seen that executive action on immigration, be it an agency policy memorandum like the one that implemented DACA, an executive order like the Muslim ban, or a rule published in the Federal Register like the 2019 Public Charge Rule, frequently results in the swift filing of lawsuits in some cases, such as the Public Health Order, frequently referred to simply as Title 42. The Biden administration has chosen to continue on popular Trump-era policies, resulting in the resumption of litigation. In the case of Remain in Mexico, the Biden administration formally rescinded the policy only to have the state of Texas and others sued to force it back into effect. Other cases, such as those related to the backlog of applications for employment authorization documents, EAD, will continue simply due to the fact that USCIS has as yet been unable to clear the backlog regardless of a change of leadership at the top.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!